Freitas and Marzukos Construction and Coatings Incorporated. Okay, well, I see we have both counsel. Mr. Brockmeyer, I believe you represent the appellant, is that correct?
Yes, it is, Your Honor.
And did you wish to reserve any time for rebuttal?
5 minutes, please.
Thank you, sir. We are ready. You may proceed.
Thank you. May it please the court, Alex Brockmeyer on behalf of Jonathan Freitas. We're asking that this court reverse and remand for further proceedings on the duty to maintain and the duty to warn because the trial court erred in granting summary judgment on those two duties based on the open and obvious danger doctrine. First, talking about the duty to maintain. Regardless of how this court rules on whether this uncovered nature of the drain hole was and whether it was or was not open and obvious, this court in cases like Cook versus Bay Area Renaissance, Scala, Knight has held that an open and obvious danger does not discharge the duty to maintain. And in Scala, this court considered this issue in the context of an injury to a worker like my client who was on a construction site and where the general contractor like Marzukos was responsible for maintaining that construction site in a safe condition. And in Scala, this court reversed and held that there were fact questions on the duty to maintain because the general contractor could have anticipated that the worker would encounter the dangerous condition there in order to complete his job.
Can I just ask a quick question on the factual scenario? Your client claims to be the sole provider of the facts and they were all undisputed. Is that correct?
Well, there was only my client's deposition relied
So
upon.
there's no countervailing evidence or affidavit of any kind to add anything to the formula, to the factual formula?
Correct, Your Honor.
So your argument strictly today is going to be a matter of law?
Well, I mean, our position is that my client's deposition creates fact questions regarding what...
Because it was foreseeable that some gust of wind would blow dust in his eyes and he would close his eyes and continue to walk into the uncovered hole, so to speak.
Well, that would be it for the duty to warn, Your Honor, because it was foreseeable that something could distract my client's attention. In this case, as he said, temporarily blind him and preclude him from being able to see the uncovered nature of this drain.
But I guess my question is it foreseeable that someone would keep walking in a construction site knowing there's an uncovered hatch there that they might have forgot about and close their eyes and keep walking with their eyes closed, even though there's dust in there? There's no dust covering his ability to see the opening. That's my question.
Well, so we'll take that in 2 points. First, as to the duty to maintain. What we're looking at is, just like in Scala, it's would you choose to, or could you foresee that someone would encounter the risk associated with the condition here, which is, potentially encountering this uncovered drain hole. And I mean, in Scala, there was no dispute that the person entering the garage saw the debris and yet still chose to encounter that debris so that he could complete his work. And this court focused on that in reversing and saying there was a fact question as to the duty to maintain because it was foreseeable from the general contractor's perspective that the worker would say, look, I got to complete my job. I'm here for a reason. I need to get paid. And to get paid, I may have to navigate parts of this construction site that are dangerous, but that's what makes it foreseeable. And to Your Honor's question about, should he have not walked? Should he have waited? For purposes of the duty to maintain, what Scala says is that is a comparative negligence question that the jury should consider and weigh and say, look, you maybe should have waited, but, you could also say, and this is something that the jury could also consider, the last time my client was at this job site, this door was marked off with caution tape. And the reason it was marked off with caution tape was because Marzukos was doing work outside of this door. And my client testified that the marking off of the door was done because of the unsafe work being done on the other side. So when he comes back to this job site after a week off, he testifies that, look, I thought this door was safe to use. And that's all something that the jury can take into account in considering whether or not there is or is not comparative negligence. But the points that Your Honor raised, particularly as to the duty to maintain, in light of this court's decision in Scala or in Knight. Knight's another example where, I mean, there, the gentleman walked to the corner of the roof and stepped in a hole that he created. And the court still said, this court said, there's still a fact question as to the duty to maintain because, look, this uncovered hole in the roof, the uncovered drain here is dangerous. Someone could trip in it and hurt themselves, as illustrated by, say, the first district's decision in Huck. And when you have a worker who needs to complete his job, that's what's foreseeable, that someone could say, look, it's a risk, but I'm going to have to do it to complete my job. And that's where we have the fact question here. And so based on this court's decision in Scala and Knight, the first district's decision in all cases where there was an open and obvious danger that the worker, the injured person knew about, and yet still encountered it to complete his work, that situation likewise exists here. And the same factual question that existed in those cases, which was, could the general contractor, the land occupier, anticipate that the worker would say, look, I got to do my job, so I'm going to have to risk it, is existent here. Because like my client testified, and this was the same facts in Scala, this was the most direct route for my client to complete his job.
Well, I mean, you're talking about facts that are not in dispute, but your interpretation of the case law seems to me leads to a conclusion that there can never be summary judgment in this type of a case. And I just know there can be summary judgment. So my question becomes, under what factual scenario would you agree, under the case law you're interpreting, summary judgment might have been proper? What else would have had to occur in this case?
Well, and just so I'm clear, Judge Valenti, are you talking about as to the duty to maintain or the duty?
Well, I'm talking about both, the duty to maintain, duty to warn, open and obvious, you name it.
Well, I think as to the duty to maintain, I mean, the case law says that typically this is a fact-intensive matter where the open and obvious condition really is just a comparative negligence question. I think maybe what would tilt it in favor of there being a no duty to maintain issue is where, say, the condition was not dangerous. For example, I know this court has said in the context of landscaping is a natural condition. It's not inherently dangerous, and because it's so open and obvious.
I didn't mean to get you too off track, but I thank you for taking the ability to try and answer that. That wasn't quite my intent. I don't want to cut into your time, and that would take too much time to keep going on that. So you can move on to your next point.
Except that I want to cut into your time a little bit. And my question is this, and I don't know if we have record on this or not. What was this? I want to know what record we have on the source of the concrete dust, whether it was a perpetual or occasional condition, and whether we know by whom it was generated.
So we know that the concrete dust was created by Marzucco employees, and that was
how do we know that?
Because my client testified to that and identified them based on his prior experience at this work site, as well as the apparel they were wearing, which was saying that it had a Marzucco emblem on their shirt. There is no evidence as to the frequency of this dust, but it was a construction site. And then I think Your Honor asked a third question, which kind of overlapped with the first question, which is how do we know who was doing the concrete grinding? And again, I think from my client's deposition, he was able to identify it as Marzucco employees based on what I've already identified.
And so my last question on this was the concrete grinding or generating of concrete dust something that was sort of a perpetual activity on the site, or was there a specific project that was being done that day or the day before, the day after, and only for a limited duration, involving the kind of concrete grinding that was going to generate this level of dust?
So there was certainly concrete work going on at this job. In terms of the frequency of the dust, that really isn't developed in this record. It's not known. But there was work being done on different spots of the condominium on different phases. And so this was a different phase that, from my reading of the record, had more or less kind of began, because when my client said he was initially at the job site, the work was predominantly being done on the 3rd floor. This accident happened on the 2nd floor, and the work was just beginning to start there. So, and so my client hadn't really encountered the beginning of this work.
And your client had been off the job for a couple of weeks, is that right?
Exactly, Your Honor. And to the duty to warn point, we feel that that's a very important point here, because this job site is in a constant state of change. That's identified and developed in the record and made clear, as, I mean, frankly, as almost every construction site is. But when we're looking at this in the context of the duty to warn, really what we're looking at is, in the totality of the circumstances, is could some reasonable person using his or her ordinary senses be able to ascertain the existence of this condition? And Judge Valente, to your question earlier, you know, in what circumstances could this be decided as a matter of law? In, for example, I think the Brookie case that my opponent relies on and the trial court relied on, that could be a situation where summary judgment is properly entered, because on the same day, you have a person going back and forth and traversing and navigating around a dangerous condition, having preceded it. And this is something Brookie really harped on, the contemporaneity of the encounter with the dangerous condition, such that there was no possibility for that condition to change or be rectified. And that did not exist in Brookie, but it does exist here, because of the fact that my client was off of this job site for a week. And you have a job site that's constantly changing, that he would not be in the best position to know as to what the job site is, and specifically this hole, and whether it was uncovered that morning. Because remember also, the first time he encountered this uncovered drain hole when he came back after the week off was when he stepped in this hole. So when we look at it then and juxtapose that with what we have at issue with respect to Marzukos, who is the general contractor in control of this construction site, has workers at the time of this accident 15 to 20 feet away working, doing the concrete grinding that we've already discussed, and the day before has an employee that steps in this very drain hole and injures him or herself. I don't think we know if it was a he or a she. Marzukos certainly is in a better position to know as to what this drain is in terms of being uncovered than my client, which was not the issue that we had in Brookie. And furthermore, what we don't have in Brookie that we have in this case is what is the vision obstructing concrete dust. And I think the court could look at it in one of two ways. Whether you want to say it's a vision obstructing particulate, or say it's a distraction, I think you can get to the end result, which is there's a fact question that precludes entry of summary judgment on the duty to warn, following one of two cases. If you want to say it's a vision obstructing particulate, you could follow this court or the first district's decision in Huck, where you had steam that was obstructing a French drain that was uncovered, And in Huck, like here, there were a bunch of drains on the construction site, and the worker certainly knew that drain was there. And I'm not running from the fact that my client knew this drain was present, but like the court in Huck said, it's not the drain that makes it dangerous, because if this drain was covered, just like in Huck, then the tripping hazard doesn't exist. It's it being uncovered that makes it dangerous. And the steam in Huck prevented the worker from seeing that. Here we have the concrete dust that prevented my client from seeing it. And the concrete dust also served as a distraction. Remember, he's doing this in real time, and this isn't like a Monday Night Football instant replay where we get to slow motion it. He's walking through the door, he's coming out, and the dust is sucked into his face. And so that temporarily
Need to advise you we're at 15, just so you know.
Okay. So based on Scala, or based on the duty to warn, whether it's Huck or this court's decision in Twisty Treat versus Green, which we filed as supplemental authority, which identifies the distraction doctrine rule, which can serve to create a fact question as to the duty to warn, we're asking this court to reverse and remand for further proceedings as to the duty to maintain based on Scala, Knight, and all, and as to the duty to warn based on Huck and Green versus Twisty Tree. Thank you.
Thank you. Okay, clear. All right. Mr. Anderson, I believe the floor is yours now, sir.
Yes, good afternoon, Your Honors. My name is Robert Anderson. I represent Marzukos Construction and Coatings Incorporated, and it's our position that this court should uphold the trial court's ruling granting summary judgment in Marzukos' favor, because the open drain in question was so open and obvious that it did not constitute a dangerous condition as a matter of law. I think the first thing—
Is that with or without the dust?
That is with the dust. And I'll explain that a little bit. I think to review some of the facts, we are only going off the plaintiff's deposition, and he described this as a construction zone. It's a 3-story parking garage where the pavers that formed the surface had been all pulled up. They were grinding concrete. You had bobcats that were rolling around. They had rolled through walls. There was exposed rebar. As part of the resurfacing, the plaintiff described, they had to pull up the drain covers for the drains that were in the parking garage floors, and those drains would be replaced when the new surface was put down. But that's not the stage of construction that the parking garage was in at this time. He also described that there were over 100 such drain holes, and that none of them had covers. He knew that the drain covers were not on the drains. He had mentioned it to personnel at Marzukos before. He had no reason to expect that the drains would be covered or marked. He mentioned in his deposition that there were the occasional drains that were marked, but those were marked by his company with cones, and they were temporary. He was familiar with the site. While he had not been on the site for a week or two, he had been on that site 15 to 20 days. He had encountered the drain in question 10 to 12 times. He knew that there was concrete grinding going on the day of the accident. And regardless of whether or not he had seen this particular drain within the last week or two, because they knew that the natural condition of these drains at this stage of the construction was open, that the hundreds of drains were open, there was no reason for him to walk through that door and expect that the drain was going to be covered. And in fact, he didn't do that.
But so I have a question for you. We have the plaintiff's deposition tells us a few things. It tells us that he hadn't been on the job site for several days. It tells us that the tape on the door saying, danger, danger, had been removed. and that there was concrete dust that we don't know very much about other than it obscured his vision. And I wonder why those facts alone don't create a triable issue under, among other of the authorities on duty to warn, the Home Depot Levy case. And I'm just reading from the case, there the plaintiff's testimony, which was by affidavit, was that his vision was obscured by something he was carrying, and the defendant didn't controvert that. So your client didn't offer any evidence to set up what was going on with the various factors that may have impacted this plaintiff's decision to open that door and walk out and have concrete dust blown in his face when he couldn't see the drain. And that troubles me that they're on the duty to warn issue. And I have some other questions on the duty to maintain, but let me not throw all of them at you at once.
Yes, Your Honor. So with regard to the fact that the door had been previously marked, or there had been caution tape in front of it, the caution tape was not placed there. This is what, and the plaintiff said this in his deposition, it wasn't there because the drain was uncovered. It was because something else was going on. And the fact that the plaintiff had been through there 10 to 12 times previously means that he had gone through that door before then and encountered the open drain.
When you say something else was going on that warranted the placement of the caution tape, do we know what that was?
We do not know what it was.
So it could have been concrete grinding.
I guess it's possible it could have been concrete grinding, but concrete grinding was going on across the entire project. That's what the phase of this project was concrete was being grinded floor by floor everywhere. It would be like going to a residential construction site and not expecting to walk on sawdust, which could be slippery or something like that. Concrete dust permeated this entire project, and that's clear from the plaintiff's own testimony. So the issue with the duty to warn, and the reason why I think that the caution tape was a red herring, is because that warning, there's no evidence that it was because of concrete grinding, and there's no evidence that it was there because of the uncovered drain. In the pleadings, the complaint mentions the dangerous condition as the unopened drain. The concrete dust has been raised in his deposition, but that's not the dangerous condition that they are alleging that we should have warned of.
Well, can I ask you a question also about the burden of proof on a summary judgment? Listening to the description of the facts and knowing that your client proposed no theory that said something like, there's no other way to do this construction and do 100 lid removal and not have there be an open and obvious contention. So if the burden is on your client to prevail on summary judgment, why does it matter that this fellow Pratis had to have concrete dust in his eyes or not in order to walk into? He could have just walked in that hole and been looking at the sky and counting flowers on a tree. I mean, that would raise a comparative negligence question. Would it or would it not? Well,
first on the burden, our burden is to prove that there's a lack of an issue of disputed material fact, and under those facts, the law requires summary judgment in our favor. And so I think that the way you look at this, the way it should be analyzed, is like you start with the alleged dangerous condition. And in this case, it's the open drain. And you can go by the Brookie Court's analysis or the analysis that this court has given in the Miller v. Slayball case or the Knight v. Waltman case, and that the appellant has described in their brief, which is that the open and obvious doctrine does not discharge the duty to maintain where the defendant should anticipate the harm despite the open and obvious nature of the danger. So we need to look at the open drain and say, should my client have anticipated the harm even though it's open and obvious? Because the plaintiff has admitted he could see it. And he has admitted that he could have seen it if he had his eyes open. So it was.
Well, and that's pretty much the situation that was present in Scala, wasn't it? I mean, the footnote in that opinion says the plaintiff acknowledged that the debris that he tripped over was open and obvious, but there was still a fact issue in Scala about whether the contractor had maintained the premises in a reasonably safe condition. And whether or not the contractor had done that was a disputed question of fact, like it is here. And there it was sufficient to warrant reversal. How are we different?
Well, in Scala, it was a given that the debris in the garage was a dangerous condition. And I propose under the facts of this case that it's not a given that the open drain was a dangerous condition in the context of this construction site. In Scala, well, in this case, this is not a case where Mr. Pratis observed the drain and said, well, this is the only way I got to go. I'll see if I can step over it, and then failed. He knew the drain was there. He just forgot about it and he got distracted. And that's why he stepped in it.
But that's really the duty to warn, not the duty to maintain, isn't it?
Well, like I said, I think the duty to, in Scala, it was a given that the debris was a dangerous condition. That's why it doesn't go into the duty to maintain.
Well, isn't an open drain a dangerous condition?
Not in the
know about it.
In the context of this construction site, it's not a dangerous condition. There's hundreds of them, or there was at least over 100 of them across the construction site, and that was the stage of the construction they were in. I mean, I think that people brought up the planters, the line of case that goes along with the planters earlier with a question, and it's unquestionable that if you walk through a planter, it could be dangerous to you because there could be roots that could trip you. There's things like that, but that's the natural condition of a planter.
So your argument is essentially a legal argument that as a matter of law on this record, the summary judgment is proper because there is no other outcome. Essentially.
Yes, Judge.
And so what I wanted to set the stage because I have a question for you. I read most of the key cases you all cited, and I looked at some other cases, and the only case that I came across affirming a summary judgment on facts along the lines that we have here was Brookie. Every other case on either duty to warn or duty to maintain that is in this universe, at least as I was able to ascertain, found that there was a fact issue on one or the other or both of warn or maintain. So my question to you is, I assume Brookie is your best case.
Well, yes, Judge, in the sense that it is a case that actually affirms the summary judgment and shows that you can, that it is possible.
That you can, it's been done. And
Yes,
somebody actually took the time to write an affirmance so we would know why it got done. What other cases are like Brookie? What other cases can you point to that support your position that this is a legal determination and there is no fact question?
Brookie cites to other cases. The one that jumps to mind to me that the most famous is the Arnold case. It's actually a Middle District of Florida case applying Florida law where a invitee is walking along a path and there's a tree branch hanging down that he sees, but that he's distracted by, and he ends up, or distracted by something else. I can't remember if he's talking to his son, something like that, and he ends up walking into the tree. And
so I didn't read the federal case for reasons that may be obvious, but I saw that Brookie, that it had been cited by Brookie. But at the outset, Brookie, which is a first DCA case, says that they're addressing the issue of whether summary judgment can be granted where the injured party observed the condition but failed to step around the easily avoidable obstacle. And isn't that the whole shooting match for Brookie? And here, my question for you is, under the circumstances with this drain being on the other side of a door, concrete dust blowing in the guy's eye, the door, him not having been on site for a couple of weeks, and the door having, until this day, at least in his experience, had caution tape, how do we know that this drain was easily avoidable, as was the case in Brookie?
Because he walked by it 10 to 12 times without a problem beforehand, and he
But
admitted
10 to 12 times 2 weeks ago, right?
it's still 10 to 12 times. It's a reason. That's a decent amount of time to walk through a door. It shows that you can get through there without a problem.
Unless there's a vortex of concrete dust blowing in your face.
Well, that goes to the well, first I'll say he not only did he navigate it 10 to 12 times, he admitted that if he had remembered it was there, he would have avoided it. And he also said if he hadn't had his eyes closed, he would have seen it and avoided it. So there's the dispute is not whether or not can you avoid this drain. It's so dangerous that you can't get around it. The question really goes to, is this a dangerous condition because my client should have foreseen that a construction worker would, one, forget that this open drain was on the other side of the door that he had seen 10 to 12 times, and he's walking in a construction site with hundreds of open drains.
So one last question, I'm sorry to interrupt you again. The testimony about the 10 or 12 times that he navigated the drain, those times were in his previous days on the job site, am I correct?
Yes.
And what do we know about how those times he navigated the drain? Did he pass it? Did he walk through this door to get over the drain, or was it some general observation where he was in the vicinity of the drain?
Well, I have to admit that he did not detail every time that he went by, but generally he said that he opened the door and stepped to the left of the drain. Is my recollection.
Okay, thank you.
I have another question that might be a little bit weird, but here's what I'm starting to think. When I heard you talk about 100 open drains, 100 open drains, and I'm going to say, okay, I got 100 workers walk across that field, each do jobs along the way. Isn't that like a minefield? But we've labeled the mines. You can see the mines. We've got a red flag on each landmine. So we're not asking you to do anything that's not open and obvious. Just don't walk where the flags are. It just seems to me that you could make the argument, well, it's pretty obvious of all the people working on that construction site, somebody's going to walk into one of these uncovered drains. I mean, just the odds. Someone's going to walk into it for whatever reason. So maybe the focus shouldn't be on this one particular thing, but the fact that there's 100 of them and there's people required to work there, someone's going to walk into a trap. So I'm not sure my analogy is correct about a minefield, but that's kind of rattling around in my brain that the facts here are undisputed, and you've got 100 open lids. Say, it's fine, it's open and obvious, therefore, well, we don't have liability. I'm having a problem with that analogy, are you?
I understand what you're saying, and I do think that there is a baseline where we have to understand that there are dangers that present themselves in a construction site based on the stage of construction that we would tolerate in places that we wouldn't tolerate in a grocery store, for example.
So I'm sorry, I know I've interrupted you a lot. When you say there are, places of danger on a construction site, it brought a question to my mind, which I had noted in reviewing this. What do we know about the door having been taped before, and who decided and when to untape it? And the reason I'm asking that question is if your client was the person in charge of deciding whether to have caution tape on the door or not, is there any record of what the reason why the caution tape came off on this day?
Judge, the only record of why not in the universe, but in the record in front of us for appeal is the plaintiff's testimony, which was that he did not know exactly why the caution tape was in place, but it was not in place because of the drain.
He didn't think it was in place because of the drain.
Yes, I think his words were something to the effect that they were doing dangerous work on the other side. He didn't specify.
He thought that was why the caution tape was there.
Yes.
And your client didn't address that with any evidence, going to the reason and the circumstances surrounding the placement and removal of the caution tape.
No, Judge, and I don't know if it matters, because under the context of the drain being open, which is the dangerous condition that's being alleged, the plaintiff concedes that, or the appellant, the plaintiff in his deposition conceded that the caution tape wasn't there because of the open drain. So he wasn't arguing that, oh, I saw there was no caution tape, I thought I could go through scot-free. He still knew that there was an open drain on the other side. He just temporarily forgot. And that really comes down to,
we could infer that if the caution tape had been on the door, he would have been ill-advised to go through the door, right?
if the caution tape had been out through the door, he would not have been allowed to go through the door, I think is fair to say.
And that's an inference that would necessarily be drawn at the summary judgment stage against your client.
It could be, it can be an inference that's drawn. As far as my argument goes, I don't think it matters, because it's conceded that he had walked through the door, that he was allowed to walk through the door, and that there was an open drain on the other side of the door, and that the caution tape was there for other purposes. So
but those purposes would have kept him from walking through the door, whatever they were.
The only thing that would have kept him from walking past an open drain on this construction site was a fence around the construction site that was locked and would prevent him from getting on the premises.
Or a door that had caution tape on it in front of the drain.
That would have kept him from that particular drain, yes. But again, I think when you look at the Knight and the Miller cases, where the second DCA gave the exceptions, the 3 rules that we look at to try to see whether or not an owner should anticipate a particular type of harm. One was that the invitee will fail to protect himself because the advantages of encountering the danger outweigh the apparent risk. I'd argue in this case that doesn't matter, because the plaintiff did not choose to encounter this particular risk. He didn't see the drain and say, okay, I know there's a drain there, but I got to go through there anyway because it's the quickest way. That factor I don't think matters.
Mr. Anderson, I need to advise you that your time is past expired, but I'll provide you at least another 30 seconds to sum up, if you would.
Okay. The other 2 exceptions, where the invitee was distracted so he could not discover the harm, and that the invitee would discover the harm and forget about it. And what we have in this case is kind of a double whammy, where they're alleging that he forgot about it, and that he was distracted by something that was common on the construction site. So I'd argue that this is not a dangerous condition as a matter of law, because there's no way that an owner could reasonably expect that it would be probable that a worker on the site would both forget about the drain and be distracted by something normal on the job site. Thank you.
Thank you, counsel. Okay. Mr. Brockmeyer, you have 4.5 minutes remaining.
Thank you, Your Honor. First, my opponent I think conceded just right now that the distraction doctrine would apply in this case, because when he was talking about why he stepped in this hole that was uncovered, he said, quote, Mr. Pratis got distracted and forgot about it. I mean, that's the distraction rule right there. We have an external source, the concrete dust, that my opponent just said distracted my client, and that resulted in him stepping in this drain hole. So on the duty to warn, I think that concession right there creates the fact question that precludes summary judgment as to the duty to warn. Judge Valente, you talked about the minefield, and in this case, someone actually stepped in the mine, or on a mine, the day before this accident happened. This very drain, someone stepped in this hole that was uncovered. And so, I mean, we know it's dangerous, and it's in the record that leaving these drains uncovered was a safety violation, and that the drain covers should not have been removed. And Marzucco's knew this. I mean, they were the ones who covered the drains before this accident with a cone or with plywood. And there's record evidence from my client and his deposition that this specific drain, we want to really drill down to the one that caught my client stepped in, Marzuko's covered before this accident.
Give me the record site on that, please.
So it was Marzuko's job to cover the holes. That's record 277, lines 4 through 5. And for this specific hole, record 311, lines 18 through going on to page 312 of the record, line 5.
And the part of the record where the other individual stepped in the drain the preceding day.
Let me see if I can find that for the court real quick. Having an issue.
I don't want to hold you up and you've only got a
It
couple.
was definitely cited in our reply brief. I know that for a fact.
Okay,
Um,
I'm sorry, I ate into your rebuttal. Keep going.
So then my opponent talked about the caution tape on the door. My client said in deposition that he didn't have any reason to suspect that this door was unsafe to use, and said that because of the fact that the caution tape was in fact removed. And that starts on record page 272. And it's really all on page 272, specifically lines 20 through 22, where he goes, it didn't cross my mind that it was still unsafe with respect to this hole in relation to the caution tape. Now, my opponent talks about the Middle District case, the Arnold case. That case was distinguished by Burton out of the 4th District with respect to the duty to maintain. And as to the duty to maintain there, the plaintiff had warned her supervisor about a pothole a week before and still stepped in the pothole, and the court said there's a fact question as to the duty to maintain and distinguished Arnold. So we would submit that, you know, Burton is more in line with this court's cases in Scala and Knight. The last thing, I think it was Judge Valente, you had talked about, you know, prior jobs and whether some like course and pattern of practice and not covering these drain holes. But in fact, my client worked with Marzuko's on other jobs and testified that on those other jobs, Marzuko's actually covered the drain holes and did not leave them uncovered, as was the case here. So in conclusion, we would request that this court reverse the summary judgment and remand for further proceedings as to the duty to maintain as well as the duty to warn. Thank you.
Thank you, counsel. Before you depart, Mr. Brockmeyer, are you in the old Lee County Courthouse, the historic one?